The next presentation is one of the XRP community's finest. This individual is quite literally part of an army, a decentralized army of legal analysts that the XRP community quite literally crowdsourced from the internet. Mr. Bill Morgan and his company, they are sponsors of this event, Morgan Mac, and I believe they're also part of the lawyers and the legal team of Wave of Innovation. Bill, you've been working endlessly throughout the course of the SEC case and accompanied with plenty of other lawyers to give us the information we need and we have no idea about to figure out why the hell we got sued, right? I think that every single person here is nothing but grateful for all the people that selflessly took the time out to try and help us figure out what happens next, where do we go. All these legal hurdles are preventing the innovation from continuing. And with all these people coming together, this is how we make progress. It's my absolute pleasure to introduce Attorney Bill Morgan.
Thank you to the Bearable Bull.
Well, regulation in Australia is a topic, and it can be a dry topic. So I'm going to try and deal with it in two ways. Firstly, I'm going to look at what I think is the thinking behind where the policy towards reform and regulation is heading in Australia. And then secondly, I'm going to deal with a very important case in the Federal Court of Australia that was delivered about 4 weeks ago. And as I go through where I can, because I think it's probably fair to say that most people in the XRP community, including most Australians, know more about the situation in the US than they do about the situation in Australia. So I will try to relate back to the SEC Ripple case and to the US situation where I can, but the primary focus nevertheless is on where regulation is heading in Australia and the extent to which there is enforcement by our principal regulator, which is the Australian Securities and Investment Commission. So what you'll hear the word financial product in this talk, and that is broadly the same, not exactly the same, but broadly the same as the term securities in the US. So it's a very large level of overlap. So if you're an American, just think of securities when I say financial product. So this is a really fundamental question. Is there regulation of crypto in Australia? Because you often hear people say that crypto is unregulated, but of course, if it were not regulated at all, then I could simply I could leave now and go to the hydrate bar because that'd be the end of my talk. But it is, it's an asset. Crypto is an asset. It's a form of property in a legal system. So therefore, to some extent, it will be regulated, even if people don't know where the boundary lines of regulation are. So the regulations that we have at the moment are principally AUSTRAC, the Australian Transaction Reports and Analysis Centre. So that's your regulation that deals with anti-money laundering and counter-terrorism financing. So that's the KFC side of know your own customer side of regulation. And that applies to all the exchanges in Australia, such as CoinSpot and SwiftX and all the other major exchanges that are located in Australia. And then, of course, the Australian Taxation Office, like its American equivalent, never misses out. So the Australian government got that part of regulation in order very quickly. And there's income tax if you earn income, such as rewards on staking. There's capital gains tax when you sell or exchange cryptos. And there's goods and services taxes if you use crypto as a payment for a good or service. So that's something that I'm not going to talk anymore about. That's really, something you should speak to your accountants about. My accountant told me that if you think that you are dealing with crypto and the Australian Taxation Office can't track it, you're crazy. And then finally, there's the Australian Securities and Investment Commission. They've, unlike the SEC in the US, have produced some policy papers, some guidelines. And one of those policy guidelines has that statement, which makes it clear that the position of ASIC is that at least some crypto and some crypto activity falls within the Australian Financial Services licensing regime. Now, we are heading towards further regulation. There's a consultation process that's been going for a couple of years now, and that's been managed by the Australian Treasury, not by ASIC, the financial product regulator, which is interesting. And it is a reform agenda for crypto that does commit to developing appropriate regulation, including some new level of regulation. And the consultation paper on token mapping was the first major consultation paper released by the Australian Treasury. That was released in February last year, and that started the process. So why token mapping? Token mapping is a foundational step, according to the Treasury, in getting the regulatory framework right for crypto. So they went through that token mapping exercise, and there was a public opportunity to respond to the consultation paper. So my firm did do a partial response. There was over a dozen questions. We answered questions 1, 2, or 3. So if you want to read our consultation paper, I have some copies of that in the Morgan Mac exhibit. And we answered questions 1, 2, or 3. I'll just quickly, I won't read it out. You can pick up the brochure if you're interested. But one question that we asked was, we answered was question number 1. What do you think of the role of government in the regulation of crypto? So a really general first question in the consultation paper. What should that role be? The second question that we answered was question number 2, which is, what are your views on potential safeguards for consumers and investors? So I specialize in consumer law, so that's professionally for me, that's an important question. And the last question was a really interesting one. That was question number 5. That's the last one that we did a response to. And that question had 2 parts. One question was, what are the additional supporting reasons or alternative views on the value of a bespoke taxonomy? And the second question was, what are your views on the creation of a standalone regulatory framework that relies on that bespoke taxonomy? So really interesting question, because on its face, it opens the possibility of a completely standalone regulatory framework. I don't think that the Australian government has any intention of having a standalone regulatory framework, but to understand that, you really need to read that consultation paper and the next one. It makes it clear that the government is not going to agree to a bespoke regulatory framework for crypto. Now, the first consultation paper on token mapping, it adopts an approach that is consistent with the BIS, which is the Bank of International Settlements. So it's a technical approach to the description of the crypto ecosystem as a whole. And there's a legal approach in mapping the ecosystem against specific portions of the current financial services regulatory framework in Australia. And when you look at that approach, then it is obvious that the government already knows that whatever crypto regulation whatever legislation is ultimately passed is going to intersect with the current financial services regulatory regime. So the BIS approach is consistent with a policy that's been adopted by Parliament in Australia since 1996, which is a policy of functional equivalence between digital asset products and other financial products that are not digital assets. So that leads me into the second consultation paper, which was published and released on the 16th of October last year, so not so long ago. And that has a telling name, which is Regulating Digital Asset Platforms. And there was a very important ancillary fact sheet, which was like a summary of the proposed paper. That submission is closed on that consultation paper on the 1st of December 2023. So that's really now in the hands of the government, and they haven't released yet. I checked a couple of days ago, they haven't released yet any of the papers that were submitted, but they ultimately will. And I would suggest, from having read that consultation paper, that the real policy problem or concern is intermediary risk. That's why it's targeted at digital asset platforms, and that is obviously in the wake of XTX and all those other disasters over the last couple of years. So that's the focus, intermediary risk. And that risk is amplified, according to the Australian Treasury, by the vertically integrated nature of digital asset platforms, where and this is something that, one thing that Gary Gensler has said, and is probably the only one, where I think he is partly on the money. There is a risk of conflicts of interest when you have a platform that is holding your crypto, allowing you to trade, and also possibly, depending on the product, like an earned product, dealing with your cryptos. So that really amplifies the intermediary risk that investors in crypto who have their crypto on exchanges, and many of you won't, because you've probably been in crypto long enough to know that it's better not to have it on exchanges, at least not for long periods of time. But there's many people that just have their crypto sitting on exchanges all the time, and the government is aware of that. So this is really from the fact sheet, the ancillary fact sheet. I put that up just as a sort of snapshot of what the government is thinking. So you can see that they expect that some of the activities, and I'll come to why this is important in a minute, some of the activities are focused on what they consider to be financial activities. So you can see already there's an assumption that the Australian Financial Services regulatory framework applies. And then they talk about other activities, and they give some examples: video game businesses, health and fitness, ticketing, which are clearly not financial services. But their intention is to have some additional regulation that covers those non-financial activities. So more than the first policy paper, the second policy paper made it abundantly clear that the government will leverage existing Australian financial services laws. So I think they always knew that. And the question that I referred to before, one of the questions that my firm answered in our response to the first consultation paper, talked about it, should there be a bespoke crypto framework? I think they always knew there wouldn't be. There is a threshold. It's a ridiculous threshold in my view, 1,500 for an individual or 5 million in aggregate. I don't know what happens if you have $1,400 worth of crypto and, or that's your largest holder on an exchange, which is completely improbable. And then suddenly, you have one of those spikes and it doubles in value. So I think effectively there's no relevant threshold for any major exchange. Now, there are crypto-specific obligations and activities that the Treasury is focused on, which will be the subject of some special regulation or some changes to the existing financial services legislative package. One is standard form platform contracts. So the government will probably want a standard form. Minimum standards for holding tokens. So custody is a really big issue for the Australian government. And standards for custody software and standards when transacting in tokens. So specific activities which will be covered by any new legislation will be trading, staking, tokenization, and fundraising. The important thing to note, I think, when you read particularly the second consultation paper and the ancillary fact sheet, is that unlike the SEC, which seems to be focused so much on the tokens and says that all tokens except Bitcoin are securities, the focus of the Australian Treasury is not on the token. So it's on the activities of the intermediaries where they're primarily focused. So I think it's really important to just have a look at that second bullet point and see what I've italicized there, which comes from the second consultation paper. Many digital assets are not financial products. So that's a very different starting point than the SEC. Many digital assets are not financial products, but holding assets, custody of assets, is the regulatory anchor point. And that's the expression used in the second consultation paper. That's the regulatory anchor point where the government is particularly focused. I'll just go back for a moment. That last point too, to accommodate a future where an increasing number and variety of products are tokenized. So there may be people who say that crypto doesn't have a use case. There's politicians who call anyone who talks about crypto bros in a critical, pejorative way. But a major government, the Australian government, expects a future where an increasing number and variety of products will be tokenized. And just the last point I'll make on this topic is that there are products that are not financial products, but what crypto is allowing and tokenization is allowing is an increasing financialization of non-financial assets. And what I think will come from eventually in legislation is where products are not financial products, so not securities, but they're increasingly financialized, that is the gap that will be filled by more crypto-specific legislation. Now, the paper also gives some examples of what are not financial products. So digital assets are used in non-financial industries such as video, gaming, media and entertainment, healthcare, fitness and lifestyle, and gambling. Also digitally native assets that are technical components in network infrastructure, which will be a defined term, but it basically means public crypto networks. So it's pretty clear that tokens like Bitcoin and XRP are not considered to be themselves financial products. We don't need a case, I think, to tell us that in Australia. And then tokens that record messages as part of a decentralized social media protocol. So there's some specific examples of tokens or cryptos that are not financial products. Now, I have to talk about enforcement if I talk about regulation, because, you know, we've all heard the term regulation by enforcement, and Australia is no different. Where there's gaps, the ASIC, the regulator, may still commence legal proceedings, and has commenced a number of legal proceedings. And if you go onto the crypto page on the Morgan Mac lawyers website, that I've got case notes on 4 or 5 cases, but the one I want to focus on today is what I call the block earner case. That's ASIC against Web3 Ventures Proprietary Limited. So that decision, there was a hearing on the 31st of January this year, and remarkably, it might even be the most remarkable thing about the case, judgment was delivered 9 days later. So I normally have to wait 9 months for a decision, but ASIC got lucky. So that decision was delivered on the 9th of February by Justice Jackman in the Federal Court of Australia, which is a very major court. There's a state and federal division in the court system in Australia, and in the Commonwealth system, the federal government system, then the federal court is the last court before the High Court, which is equivalent to the US Supreme Court. So the block earner products in that case, I'm just summarising the facts really quickly. There was 4 products, but there were 2 kinds of products. So there was a fixed yield product. So this is a typical earn type product. You see them in some of the US cases as earned or lend type products. Fixed yields between 4 to 7%, so not variable. So it's a promise. That'll become relevant later when I look at the reasoning for the decision in this case. And the underlying assets in the 3 different fixed yield products were USDC, which is, for those who don't, not everyone here knows a lot about crypto. USDC is what's called a stable coin. So 1 USDC is pegged to 1 US dollar. Paxos Gold, which is backed by gold. So it's backed by real gold. It's stored. And then Bitcoin and Ethereum, which for the people who don't really know crypto very well who are here today, are the 2 biggest cryptos by market share. And then there was a variable product, which involved USDC, Bitcoin and Ethereum. And that led to Block Earner, which is the company for Web3. Block Earner investing that or passing on those tokens into the Aave and Compound decentralized finance protocols. And that was called the access product. So we'll just group the first 3 and call them the earner products, and the last one, the access products, for the purpose of just going through some of the facts of the case. So these were the issues that the court had to deal with. The 3 numbered items are all financial products, so they're all a form of security. A managed investment scheme, which, and anyone who follows my posts will know that I've identified that some time ago as the product most closely related to the US investment contract. Then another one, which is sort of related, but it's called an investment facility. And then lastly, a derivative, which is a product that tracks the movement in another underlying product. So I'm going to just deal with the managed investment scheme so I can relate it to investment contracts, and I can relate it back to the SEC Ripple case. So I prepared this table on Friday where I compare elements of the managed investment scheme to an investment contract. So I think where I've highlighted in green, firstly, the first thing to say is contract and scheme in the heading, they just mean the same thing. It effectively means a contract, a transaction, or a scheme. So there's parity there. But looking at those particular items I've highlighted green, contribute money or money's worth is the same as an investment of monies, because the cases on that have followed the Howey test have said it doesn't have to be money, it can be money's worth. Secondly, you can see that there's the reference to common enterprise, which is really important, and to pooling of assets. Then you've got some other elements in those first 2 rows. As consideration to acquire rights or benefits produced by a scheme. Now, lawyers will know that consideration is a term that relates to contracts. So it's an element of formation of a contract. And rights usually arise from some sort of promise or contract. So, and that's in that first element. So this is a real issue, as you know, in the US cases about whether the SEC has gone too far in saying that you can have a scheme that just has no underlying contractual right or obligation. As we all know, Ripple owes us there's no rights or obligations between Ripple and a person who buys XRP on an exchange. So that's one difference. And bearing in mind that the investment contract is a court-decided, the test for it, the Howey test, is a court-decided test, whereas these elements of managed investment scheme are part of the definition of financial products in Section 9 of the Corporations Act. So that means every time the court has to interpret elements of a managed investment scheme, they've got to go back to the underlying purpose of the Corporations Act. In the second row, again, it's different. There's the common enterprise. You don't really have that reasonable expectation of profits element. And that's really important because we don't have this hypothetical reasonable investor that you can create out of a bunch of promotional type activities and say, oh, this hypothetical investor, he might have bought XRP in 2014, or he might have bought it in 2023. He might have bought it to hold. He might have used it for payments. That just, you don't have that one only for all purposes, for all time, hypothetical investor with a reasonable expectation of profits. But when you look at the last row, I think they are comparable. To be derived from the efforts of others means you are relying on someone else. And I would suggest that the Australian test for managed investment scheme is really getting at the same thing. And that is you're handing your crypto over to somebody or your money over to someone and you're relying on their efforts. So with that sort of little comparative in mind, just looking at what happened in the case. So I'll deal firstly with the earner products. So Block Earner on its website under FAQs stated that Block Earner is able to generate returns by gathering customer funds, that's the pooling, and lending it to their trusted partners. And I assume one of their trusted partners was FTX, to receive a favourable yield rate. And then ASIC contended that the earner product satisfied the test for managed investment scheme because you had all elements satisfied. You had consumers giving money or digital assets, either one, to Block Earner. So you had the contribution, you had the promise of a fixed yield rate, and consumers did not have day-to-day control over the management of those products. So it was a scheme and it satisfied the entire test for a managed investment scheme. And just like the SEC would when it prepares these cases, you can see it relies on things that are said in blogs and white papers and on the website. ASIC looks at those same facts because that is what distinguishes one product from another product. They also looked at the fact that the promise was a fixed yield. So it didn't fluctuate based on whether Block Earner was profitable or not. It didn't fluctuate on the performance of those underlying assets, Ethereum, USDC, Bitcoin, and Paxos Gold. So it was a specific promise. And that was very influential in the court finding that was a financial product, a form of security. It was a very different outcome, though, when we came to the access product. Before the judgment was delivered, I thought maybe the access product was more at risk. The reasoning of the court's really interesting. I've done grave injustice to Justice Jackman's reasoning by reducing it to 1 point, but I sort of figured I only have 2 minutes and 13 seconds left by this point. But what happened with this product is that people sent cash or crypto to Block Earner, and they put that into an omnibus account. So the ASIC said, there's your pooling, there's an omnibus account. And then it was put then or invested into those Compound and Aave decentralized finance protocols. So, well, it sort of does look like common enterprise and pooling. well, except that the court just didn't agree. So here's the overall result, just in summary. The earner products were managed investment schemes. Access product was not an investment scheme, and in fact, it wasn't anything. It wasn't an investment facility, and it wasn't a derivative. The court found that the access product was a scheme, and they also found that that's the part of the first element. And they also found that the consumers who invested in the access product did not have day-to-day control over the operation of the scheme, but they found that none of the other elements were satisfied. And one of the reasons was because the term contribution, according to the court, so it's not in the language of the statute, but according to the court, conveys a joint rather than an independent action. So it can't just be you merely buy a token. That's not enough. There has to be some joint action. So it is a more confined term than what you could possibly get under the Howey test. The Howey test is more flexible, I call it more stretchy, more stretchable. But the managed investment scheme has some very critical elements like this element that prevent it being, you could never possibly say that a managed investment scheme is every offering of Ripple for 8 years. Can't happen on the basis of the decision, the court jurisprudence on the managed investment scheme. And importantly, the court, despite the omnibus account, the court was aware that there was a division in the records between who retained ownership. So there was a DeFi token that was swapped for whatever was invested into the liquidity protocol. So I don't really know much about these DeFi protocols, but you get an LP crypto, and that was put in the omnibus account, but it was still traceable to every individual investor. So the court said that's not pooling. That's not pooling, and found that that element, which is a very critical element, that common enterprise element, had not been made out. So that's been the most important case today. So if you only read one case to see where we're at with enforcement, you'd read that one. And there's a much broader summary of that case on the Morgan Mac Lawyers website. So I've just done a very quick summary of the case. That's all I have to say. Thank you very much.